Let's, Krista, if you're ready, let's just begin the webinar. It's 2:02. People can still are still joining us, but we will just start things off for this in keeping with that time, of course. Thank you, everybody, for joining us for the fourth webinar on the series Navigating COVID-19, Managing the Contractual and Related Legal Protections and Risk for Construction Companies. My name is Kenny Leon with the Canadian Construction Association. Before we begin, a few webinar etiquettes. Please do mute your audio. For questions, please use the question box and we will answer them at the end of the presentation. So keep the questions coming right throughout the presentation when you have. But of course, we will answer them at the end. The presenters, the panelists will answer them. Thank you. As you may or may not be aware, we have had a series of webinars on navigating COVID-19 under various topics in the best interest of our members and our community. And today's topic is by very, very popular request that we have had this discussion amongst our members as well. So this is a topic that's of being very, very interest and of course, rightly so, given the times. Sincere thanks to our corporate member BLG for presenting this webinar. On this webinar today, we are delighted to have as our expert panelists, Krista Johansson, partner BLG. Krista, if you can just give us a wave. And James Woods, senior associate construction at BLG. So I'll leave it to Krista and to James. Over to you.
Hi, everybody. Thanks for joining us today. James and I are very pleased to be presenting to you on how to manage some of the risks associated with the current COVID-19 situation. The presentation will be about 40 minutes. And then, as Kenny said, we'll be open to questions at the end. Obviously, we can't provide you with legal advice on any specific project, but we'd be happy to answer whatever general questions you might have about the situation. And in the interests of not being distracting, I'm going to turn off the video for the slideshow. Okay, so the timeline of the COVID-19 pandemic is a bit relevant here, and I just want to highlight a few dates. So the outbreak was first reported in Wuhan at the end of December 2019, and the first Canadian case was confirmed about a month thereafter. End of January, the WHO declared a public health emergency of international concern, and a pandemic was declared about 2 weeks later on March the 11th. Following that, Quebec was the first province to declare a state of emergency on March 13th, and then other provinces followed, and subsequently there were also various bans on gatherings of large numbers of people. The Canadian border was closed to non-essential travel on March 18th, and by March 22nd, all provinces had declared states of emergency. The BC Provincial Health Officer, I'm in Vancouver, issued guidance for construction sites on March 22nd. A few days later, Quebec suspended all non-essential construction work, and their definition of essential construction work is somewhat limited, as you'll see. And then BC ordered closure of non-essential businesses a few days later, but construction was declared essential, and in most of the Western provinces, that's similar. And then on April the 5th, Ontario also put some pretty strict limits on what is essential construction work and what isn't. So the situation across Canada right now really varies. In general, in the Western provinces, construction has been declared to be an essential service, and construction contractors are either suggested or required to practice social distancing, increased sanitation, and other guidelines issued by public health authorities. In Ontario and Quebec, the situation is quite different. Ontario has limited essential construction to the healthcare sector to critical infrastructure, to certain work relating to petrochemical plants and refineries, typically either maintenance construction or new major projects that are already in progress, and construction to modify facilities to retool them to produce personal protective equipment and other necessary items directly related to the COVID-19 crisis is also on the list. And then finally, it's considered essential for residential construction that's already in progress. So Quebec went even further and essentially limited everything to emergency repairs and maintenance, although there's a wider exception for landscaping. But subsequently, Quebec decided that they're going to allow housing construction to resume if it's on projects that can be complete by July. And the goal there, I guess, is to ensure that the projects are available to provide housing to reduce housing shortages. Then getting into Eastern Canada, there are fewer restrictions in general. Construction has either been declared to be an essential service or essential services haven't been selected. In Prince Edward Island, new projects can't begin, but ongoing projects can continue. So these restrictions are having major impacts on construction projects across the country. Typical effects are labor availability, supply chain issues, increased site safety requirements that are increasing costs and decreasing productivity, availability of areas of the site where social distancing can't be practiced, and then of course labor issues involving employment, such as layoffs and termination. So all of these impacts are leading to parties making contractual claims under force majeure provisions, change in law clauses, and there's been a lot of discussion lately also about frustration of contract. So we'll get to all of those topics from a legal perspective. And so we'll start just in general with the concept of force majeure. Is it as a legal concept? This is not right under the law and common law jurisdictions. The word is used typically in specific contractual clauses that may or may not be found in your construction contracts. And if you have one of those clauses, then you need to read it carefully to see whether it applies. If you don't have a clause in your construction contract, then you will be limited to relying on the law of frustration of contract. And frustration of contract is a very narrow doctrine. Now, in Quebec, the situation is different, and James is going to explain that for us. In Quebec, force majeure is a concept at common law, as well as, at civil law, as well as a type of contractual clause. So James, could you explain for everybody what exactly is a force majeure clause?
Right, thanks Krista for that. Of course, when we're looking at contracts and the notion of force majeure, we are talking about a clause that specifically aims to free contracting parties from an obligation which results from an extraordinary event beyond the party's control. And of course, and particularly in common law jurisdictions where there is no specific force majeure right at law, contrary to Quebec, the contract is of paramount importance and defines your rights. Clauses differ, both in terms of the scope of what may or may not constitute force majeure, but also the relief and entitlements that may flow from a force majeure event as it's defined in the contract. Some consequences can include, of course, an excuse of the party's failure to perform the obligations. A force majeure event can also, in certain contracts, give rise to the party's rights to suspend or terminate the contract. They can also provide rights for entitlement to either delays, extensions, or monetary claims. And as Krista mentioned earlier, case law throughout Canada is different. And if you don't have a force majeure clause, we'll be reviewing the recourses hereafter. So if you can move to the next slide, please, Krista. So just to give a landscape of what people are likely to find in this, the broad possibilities of what a force majeure clause in a contract can represent, we decided to start with a general overview of the standard form CCDC contracts. And starting with the CCDC2, which is the stipulated price model, this contract does provide a force majeure provision in the general conditions at section 6.5.3. You can see in the PowerPoint that we've sort of taken up the situations that can give rise to a contractor's right to a delay extension. And we bring your attention most importantly to the last bullet point there, which is most relevant to the pandemic, of course. Any cause beyond the contractor's control which does not result from a default or breach by the contractor. So moving to the next slide. It is, of course, relevant to note that if we're looking at the CCDC2, we are talking about a delay extension because this model does not afford entitlement to payment for costs incurred by the delays, unless, of course, we're falling under other provisions of the contract, such as situations resulting from actions by the owner or the consultant. When we're looking at the specific extension which is afforded, the length is determined by recommendation of the consultant after a discussion with the contractor, and we'll broach the subject of notice later, but it's also relevant that these standard form contracts do provide notice provisions. If we're looking at the CCDC2, 6.5.4 of the general conditions provide the 10 days prior written notice, that's 10 working days, must be given after the commencement of the delay. So moving on to the next slide. Just to sort of touch briefly on other standard form contracts that are used commonly throughout the country. In the left column, we've taken up the standard form contracts which contain similar language to the CCDC2, which I just discussed. These contracts are the CCDC unit price contract, the CCDC stipulated price forms for both design build and trade contractors on construction management projects. There's also the CCDC construction management with services and construction to the extent that it has the appendix, and the CCA standard stipulated price model also provides similar languages. On the other hand, of course, if we're looking at the CCDC3, which is the cost plus, we're in a very different landscape. Essentially, if an extension is allowed, the fee will be adjusted and the owner bears the risk. Going back to the CCDC 5B, which is the construction management with construction and services, but without the appendix, there is a force majeure provision which allows for the fee and guaranteed maximum price to be adjusted. Conversely, the CCDC 5A, which is the construction management just for services, does not contain any relevant force majeure clause. And if we're talking about non-standard forms, of course, there's a tremendous amount of variation that you will encounter when looking at contracts from project to project. The first two bullet points sort of look to a broad overview of what the definition of force majeure can be. When you're looking at a given contract, you have to determine whether the threshold has been met. Is there criteria in the clause that pertain to length and the significance of the impact that have to be satisfied? In the definition of force majeure events, it's also very common to come across lists of events that do not trigger force majeure. A common example being the inability to pay. We saw above in the CCDC2 the example of fault attributable to the contractor. Those are just some examples. In terms of the relief, I mentioned earlier, it can vary very widely. Is there an entitlement to a delay extension? If we're talking monetary claims, is there a limit of liability? A lot of variation there as well. As for mutuality, when looking at clauses, it's also important not just to limit review to the contractor's rights. Does the owner, for example, also have rights that it's afforded that the contractor is not in a force majeure event? Also important to consider. And as a final note, in Quebec, there is the backdrop of the general regime turning on notions of unforeseeability and subjective impossibility, which I'll talk about a little later. But if you are looking at a clause, for example, that defines force majeure as being a non-exhaustive list of situations, you may be able to go beyond that and also apply the general regime beyond that.
Okay, so if your contract doesn't have a force majeure clause, or if it just provides for time and not money, there may be other contract clauses that are relevant, and we thought we'd discuss two of those clauses today. So one of those is change in law. And for example, again, to go back to the CCDC contract, the change of law provision provides that either party, the owner or the contractor, may submit a claim for a change in the contract price if there are changes made after bids closed to applicable laws, ordinances, rules, regulations, or codes. And so one of the issues with changes in law in this particular situation is whether there's actually been a change in law. So in some provinces, it's pretty clear that there has been. In other provinces, it's pretty clear that there hasn't been. And then there's some gray areas in between. So for example, if your province has a public health officer who has issued some guidance for what you should be doing on construction projects, that is probably not a change in law unless your contract defines guidance from public officials to be a law. Conversely, if you have a government order that has mandated that compliance with public health officer guidelines is mandatory, then you are likely in change of law territory. So it's important not just to think about what you've been directed to do on your job site, but what extent it relates to an actual change in law versus perhaps a best practice. Typically, construction contracts provide for termination by the owner if a long list of things happens, and by the contractor if a short list of things happens. Again, to take an example from the standard form CCDC contract, there's a right for the contractor to terminate where the work is suspended or otherwise delayed for more than 20 working days. But that suspension delay must be under an order of a court or another public authority. And so again, in Quebec, where most construction projects have been shut down, it's a much clearer scenario than it is in a province like BC or Alberta, where construction is an essential service and remains ongoing. That's sort of the opposite of the suspension under an order of a court or other public authority. As always, this also requires there to be no default of the contractor or subcontractor itself. That's important because I think we can give another example here from COVID-19. If the public health officer deems private construction to be non-essential and orders that sites shut down, that's not the contractor's fault. But if the public health officer has ordered that sites may remain open if contractors practice social distancing and increased hygiene, and the contractor fails to do that to the satisfaction of the health authorities, and the health authorities then issue an order shutting the site down, that would be an example of an order of a court or public authority that would be issued due to the default of the contractor. So it is important, obviously, to comply with those orders and guidelines, but also to consider what exactly is suspending or delaying the contract. Is it you? Is it supply chain issues? Is it guidelines, or is it an order? Always termination provisions require the proper notice be given, and we'll discuss notice a little later in the presentation if there's time. So on termination, the contractor under this particular standard form clause is entitled to payment for all work performed, including reasonable profit for losses and other damages sustained as a result of the termination. So if the contractor is in a situation where they can terminate, then they will be reasonably contemplated. So what do you do if you don't have a force majeure clause or a good termination clause? In common law jurisdictions, you're limited to trying to fit yourself within the doctrine of frustration. Unforeseen supervening event makes performance impossible or radically changes the nature of the contract. And this is a very blunt instrument. What it does is it ends the parties' obligations to each other. There's no ability under force majeure to suspend obligations under a contract, unlike in the United States. If force majeure exists, then the contract is over. And obviously, that's a pretty drastic remedy, and it requires a pretty drastic supervening event. So the impossibility needs to be unforeseen, and it needs to be not caused by either of the parties. So to take an example from the case law, where one party had discovered, and this is a case involving an actual force majeure clause, but one party had insisted on a clause providing for termination in the event that markets were not available for their product. And it turned out there were markets available for the product, so they purported to terminate the contract under this provision. And the court said, well, hang on, there was never any market available for your product. So that's not a supervening event. That's all. You should have done your due diligence, and you're obligated to continue to purchase this product from the supplier. So essentially, you need to ask yourself, could I have mitigated this event? And if you couldn't have, then you need to ask yourself, is performance of the contract now impossible? And impossibility is a really tough one here. Illegality is a pretty clear example of impossibility, but temporary illegality is another scenario. And in general, if something is temporary, it's just a delay. It's not an impossibility. So in the construction context, if you're delayed for a short period of time, you have to ask yourself, is this delay such a delay that radically makes performance of the contract completely different from what the parties intended? And in most cases, temporary impossibility is not going to meet that threshold. And part of that is because in a construction contract, parties have already accounted for delay. So on the one hand, time is of the essence. You've got a schedule. You've got to finish by a certain date. Seems like if there's a delay, that would be impossibility. But on the other hand, if the contract provides that you get an extension of time, if there's a delay, then you've considered that delay might happen, and you've decided what the result of delay will be and who will bear the risks of that delay. So temporary impossibility is going to be a tough one to establish. And in the COVID-19 situation, we're very limited because we don't know how long these shutdowns are going to last. So I don't think that frustration is a realistic option for most parties on most contracts, certainly not outside of the jurisdictions that have ordered construction to cease. There's very few examples of epidemics in the case law, to be honest. I think the most similar situation that we see in the case law is World War II. And obviously, we haven't really hit the World War II levels of government intervention and of length of delay and permanence of these things. If you do end up in a frustration situation, there's a Frustrated Contracts Act in every province, and what essentially they do is they deal with all of the partially performed obligations that have accrued to the date of frustration. Because if you're not 100% finished at common law, you might not be entitled to any money. And so the Frustrated Contracts Acts try to address that unfairness. James, would you like to explain the concept of force majeure in Quebec?
Yes, for sure. Thanks, Krista. Contrary to the law of frustration that Krista just reviewed, the situation is very, very different for contractual relationships in the province of Quebec. Quebec is one of the rare legal regimes in North America, along with Louisiana, that has a hybrid regime, and civil liability and contractual relationships are governed by civil code. And under the civil law, Quebec provides for certain cases of exemption from liability, including Civil Code Article 1470, which treats force majeure, or in the English version, superior force, which provides that a person may free himself from his liability for injury caused to another by proving that the injury results from superior force, unless he has undertaken to make reparation for it. And in the second paragraph, the article defines superior force as an unforeseeable and irresistible event, including external causes with the same characteristics. Now, civil law has a notion of provisions of public order in the civil code, and this is not one of those. So in other words, the parties can actually set aside the general regime and define their own rights within the contract. So the contract, even in Quebec, is going to remain the primary source of how force majeure events affect the contracting parties' rights. A good example is how is force majeure defined in a contract. If you specifically exclude an event in a contract, notwithstanding the general regime, you're stuck with that contractual framework. Conversely, if you have a non-exhaustive list in a contract, for example, force majeure can constitute strikes, war, et cetera, if pandemic's not expressly listed, well, you may be able to look to the general regime. And just looking briefly at that general regime, which also, of course, will apply if a contract in Quebec does not have any force majeure provision whatsoever. Section 1470's, which I read to you, notions of unforeseeability and irresistible event, it's sort of a two-step process. And if we're talking about the pandemic, the unforeseeability criterion is evaluated as whether the force majeure event in question was foreseeable at the time the contract was executed. And you know, the situation, obviously, if we're talking about a few months ago, this would probably be an easier criterion to satisfy, seeing as this pandemic wasn't on the radar at the time the contract in question was entered into. The second criterion, however, adds a subjective notion of irresistible event to constitute force majeure, and that's looking at whether the contracting party, when compared with a reasonably prudent and diligent person or entity placed in the same situation, would have also been unable to perform the same obligation. So when analyzing this in the construction industry, it's obviously going to be very important to work with professionals who are familiar with it. To give sort of a very different illustration of this, you know, if you look at the grocery stores in Quebec, yes, this is an unforeseeable event, the pandemic, but their business is perhaps better than before the pandemic in a lot of cases. So that wouldn't constitute force majeure under the regime. Conversely, when you're looking at Quebec, where you have governmental authorities who have ordered the closure of specific construction sites for non-urgent work, in my view, that would much more arguably fall under the scope of an irresistible event. It's a third party who is preventing the contractor from executing its obligations. So moving to the next slide.
Thanks, James. I would also point out that, you know, in addition to Quebec, in common law jurisdictions, if you are a contractor or an owner thinking about terminating a contract, it is for any reason under the contract or at force majeure in Quebec or for frustration, it's one of the most difficult decisions that you face with some of the highest risks. So it's something that should be done carefully and in conjunction with legal advice.
Yes, definitely. So I'll just continue on here. We did obviously want to include a little part of the presentation on notice. Of course, notice provisions are of paramount importance when we're talking about claim, delay extensions. I mentioned very briefly the provision in the CCDC2 for notice. The party seeking to rely on a clause must notify the other party, and considering that we're sort of at early stages and all information is not necessarily known, it's going to be important to review now and on an ongoing basis all contracts. What is the triggering event for force majeure in a given contract? Contracts with subs also. What is the time frame within which the notice must be given? What facts and justifications must the notice contain, and within what time frame? How and to whom should the notice be delivered? These are certainly all things that should be on everybody's radar on an ongoing basis. Also, when preparing the narrative in notices, it's definitely relevant to remind everyone that there is always an obligation to mitigate the effects of a force majeure event. And when you're preparing the notice, it's definitely a relevant consideration. At the same time, sort of outside of specific monetary claims or delay extensions, you should also be thinking to who else should be notified. Whether it's sureties or insurance-related entities. And moving to the next slide.
Yep.
Okay, great.
So owners are going to be looking for specific events in a notice, triggering specific clauses in the contract that cause specific delays or cost increases. And what owners are going to want to see are the explanation of the efforts to mitigate those costs and to mitigate those delays, the causation between the situation and those resulting costs, and then documentation of those costs. Now, of course, contractors may not yet possess all of that information. So we would recommend that everyone work with their subcontractors and suppliers proactively, where you've been given inadequate notice, follow up on that, establish expectations early for what kind of information you are going to need to be presenting to owners. And owners and contractors should try to work together to establish a process for providing and updating information on COVID-19 impacts. Communication is really more important than ever here. And you know, what I'm seeing is a lot of contractors are sending out general notices of delay or potential delay associated with COVID-19 and saying, you know, we'll assess the impacts as information becomes available. And that's fine up until a point, but it's really important not to just rely on that initial notice and try to deal with everything else at the end of the job, because in a lot of cases, contracts require not just initial notice within a certain period of time, but that more detailed information be provided, and sometimes those deadlines are quite short. And so if you think you're not going to be able to meet those deadlines, you should be documenting that and explaining to the owner what you are planning to do and what you are planning to provide. And owners should be recognizing that information is changing on a daily basis and it's not all available yet, but they will want to be seeing contractors' best estimates of what's going to happen with the schedule, what's going to happen with cost. And, you know, everybody's very busy trying to deal with ever-changing requirements imposed by governments and all kinds of new challenges on their projects. So it's not easy in the circumstances to document impacts, but it's not going to become easier later. In fact, it's probably going to become more difficult. So I would just encourage everybody, if you want to make your lawyers really happy, please continue to document everything that's going on to the extent you reasonably possibly can. And don't assume that you can just give a vague statement about the COVID-19 pandemic. Really think about how specific delay events are affecting your project, and don't wait until all your information is perfect. Just send what you have and reserve all your rights, and send more information when you have it. We're running out of time, so I don't want to get into health and safety obligations in great detail. I know you've all been working very hard to implement them on project sites. But I just wanted to raise a couple of issues. If a project is going to be shut down, the responsibility for securing the various portions of the site is going to need to be dealt with quite quickly. And so I would recommend that everybody have a plan. If in the event of a shutdown, how is it going to work? Who's going to do what? When are they going to do it? What's the contact information? Who's going to bear the costs as between you and specialized sub-trades or the owner? I would again reiterate that in a situation where failure to comply with safety obligations leads to the government or the owner taking action, those are scenarios where the risk associated with that shutdown will likely be borne by the contractor. I've inserted a slide about insurance and contract security just to remind you all that you should be considering what potential insurance may be available. You should think about performance bonds. Owners will be thinking about them. Contractors should be updating sureties on the situation on a regular basis, and sureties will be expecting to be kept in the loop. And there's likely to be an increase in labor and material bond claims, and if you have parent company guarantees, now is the time to dust them off and see what your obligations may be. There's not a ton that people can do right now to mitigate supply chain risks, but to the extent that you can secure alternate options or call on security, you should be thinking about doing that. And again, we'd recommend regular update meetings with suppliers and the rest of the project team to keep people informed about what the situation is and whether anything can be done about it. On future and ongoing procurement, what I wanted to really highlight was that you're going to need to be explicitly dealing with the COVID-19 situation on your contracts. If you enter into a contract during a pandemic, that pandemic is not ever going to be seen as an unforeseen event that gives rise to frustration of contracts. Similarly, if you have a generalized force majeure clause, it may be found not to apply to the situation. So what we would recommend is that parties to construction contracts think about who should bear what risks of this pandemic and expressly deal with those situations in their contracts. Finally, just to quickly get into some of the current issues we're dealing with on disputes and lien considerations. Bankruptcy and insolvency are beyond the scope of this presentation, but you should be monitoring the people that you're working with owners, contractors, subcontractors should all be, and very much sureties should be keeping an eye on the financial health of their partners to the extent that they have insight into that information. And some contracts do provide a right for the contractor to request proof that the owner has the funds available to complete the project. So that's one avenue to investigate financial situations. But keeping an eye on those entities that might be struggling is important, so that you can make sure to exercise the rights that you have prior to and during an insolvency situation. Currently, across Canada, the situation of the courts varies dramatically, but I think it's fair to say that in most jurisdictions, it's difficult to get regular commercial matters on for hearing. And this is a problem in the context of removing claims of builder lien from title. So if you have a project that is nearing completion and there are liens that are going to need to be removed, that's something I recommend that you start dealing with immediately. It shouldn't be put off. It's not the sort of thing that can easily be addressed in a day or so anymore. I also want to put caution on the limitation period suspensions that have been issued. So in Ontario and BC and Alberta, among I think some other provinces, limitation periods have been suspended for the duration of the emergency. But currently, those limitation period suspensions do not apply to the timelines for filing and enforcing claims of builder's lien. So parties should be making sure that they deal with those claims on an ongoing basis and not wait until the crisis is over. And the reason why those periods have been treated differently than others is because to suspend lien deadlines would also hold up funds on construction projects, and everybody needs holdbacks to be paid out sooner rather than later in the current economic crisis. As well, for other claims that are suspended, I would just caution you to not put them on the back burner totally, because when the emergencies end, those suspensions are going to be lifted quickly, and you're going to be trying to get a lot of new work done. So you're not going to have a lot of time to put together your claims if you haven't already been working on those. So I think it's now time for questions, and I see that there are a few. So let's go to question one. So question one is, under force majeure, are there any precedents where the contractor received compensation for costs? Is there a situation under which this could happen? We read of black swan events. Does the pandemic fit that description, and does it improve contractors' rights to compensation? So contractors can receive compensation under force majeure legislation. It's designed to deal with a scenario of the contracting obligations of the owner and the contractor are at an end, but the owner has received value for the partial work performed by the contractor, and the legislation in each province addresses how that will be dealt with. So yes, it is possible for a contractor to receive compensation under a frustrated contract at common law. Under a force majeure clause, such as CCDC 2 that does not provide for costs, I'm not aware of any case where a contractor has been awarded costs under that clause. The argument that would need to be made by the contractor would be that the contract was frustrated and the force majeure clause in issue didn't apply to this particular event of frustration. In other words, this was so unforeseen, the parties did not intend the force majeure clause to apply to it. And since I personally don't think we've reached a situation of frustration in most common law jurisdictions. I think that would be a tough argument to make right now. But if things get dramatically worse, I think we will see some contractors making that argument. However, when things do get dramatically worse, it's because there are court orders. So, government shutdown orders. So, change in law provisions are likely to also come to the assistance of the contractor in those situations. And of course, some owners, this doesn't just apply to contractors, some owners will be weighing the costs to complete and will be wanting to walk away from their projects. And actually, if the contract contains a very generous force majeure clause that provides for full compensation for the contractor, you know, it might be the owner who's trying to avoid the application of that clause. So it does go both ways. James, did you have any comments to add in Quebec to that question?
No, the landscape is actually pretty similar in terms of claims for costs.
Okay, so question 2. Under the CCGC2 contract clause 6.5.2 identifies the situation whereby a stop work order by a public authority allows the contractor to be reimbursed by the owner for reasonable costs incurred as a result of such delay. In Ontario, is the April 5th directive by the Premier considered a stop work order, which would trigger this clause? So I'm not an Ontario lawyer, but in general, a directive by a public authority to stop work is going to trigger a stop work order clause. And so the question is, have you been directed to stop work on your project? And there might be a dispute about whether your project is actually an essential construction project or not, which could create some issues for you. But in general, for projects that clearly fall under that order, this is the sort of situation that people expect to cover to be covered by that clause. The next question is, if you have a crew on a client's construction site and after leaving the site you find out they had positive COVID cases with the possibility your crew interacted with them, is there a legal or fiscal responsibility the client has for workers that are now quarantined? Okay, so it sounds like in this scenario, the issue is that the client has had COVID infected people on site, and you're concerned that those people are either going to infect your crew or that your crew is now going to have to socially isolate as a result of those COVID cases. And the answer to that is going to depend a lot on what province you're in, what your contract says, and a bunch of other situations. So there could be some relevant employment law as well that would apply. But from a construction contract perspective, the places I would think about to address that issue would be clauses relating to the owner's requirement to make the site available. So that's one of the owner's primary obligations under a construction contract, that and paying you. And so in a case where steps taken by an owner have forced people to leave the site so that it can be decontaminated, or because they have to quarantine, then that could potentially be related to the owner's obligation to provide the site. Now, of course, this gets into whether that was really in the owner's control or not. So, you know, there's in a situation like this, there's likely to be a whole series of facts surrounding that. Maybe the owner doesn't know the owner's workers are positive, right? So, but in a situation where the owner knew or was very reckless about the scenario, let's say about the situation, then that's a potential. Some contracts also provide for costs relating to contamination, and so where an owner brings contaminated materials onto site, some people are looking into whether you can make an argument that the virus is contamination, and so that would be another avenue you could potentially raise. And then in general, the prevention principle would also apply. So at common law, a party has a duty to do what it can to assist the other party to fulfill its obligations, and a duty not to hinder the other party in the performance of its obligations, and then blame that party when they don't fulfill them. So in a situation where the owner is recklessly spreading COVID-19 around the place, then a contractor could then seek to rely on the prevention principle to say, well, you can't claim liquidated damages from me when you are the person who caused all of my workers to go into quarantine. So those are some of the areas you could explore in a situation like that, but I haven't come across a situation like that. So it would really be fact dependent, so I can't really give a definitive answer. Okay, the next question is, the owner has suspended the project after they issued an award notice, but no CCD contract was signed. What costs could I charge for? I'd have to think about that one. I haven't turned my mind to the options that a contractor would have in that situation, to be honest. So I don't want to go off the cuff on that one. But if the questioner wants to get in touch with me after the presentation, I can follow up on that question. Okay, question number 5. In Ontario, the government stated that healthcare projects were considered essential. Some internal renovation projects will put more patients, staff, and workers at risk. If they suspend those types of projects due to the risk, what cost can I claim for with the CCDC2 contract? So, so I guess this is a scenario where the government has not suspended the contract, but the owner has decided to suspend due to health risk. That seems to be the scenario. If the owner wants to change the time for performing the contract, then that has to be done by a change order. The owner can't unilaterally direct a change in the contract time. So I think that would be something that the parties would have to negotiate together, unless it's a situation that would give rise to termination rights. Anything to add on that one, James?
No, that's pretty complete.
Okay, question 6. If a surety steps into the shoes of a contractor in a claim situation, would they have a force majeure defense available to them? How does this change if their contractor client did not alter the contract on this basis prior to their failure to complete the job? The surety generally has all of the same rights that the contractor has. So if the contractor has no obligation to complete the work, then the surety would have no obligation to complete the work. So the subsequent question of how does this change if the contractor client did not alter the contract on this basis prior to their failure to complete the job. I think the question there is suggesting that the contractor has maybe just ceased to perform without invoking its contractual right not to perform. And I think the answer there would likely be whether the surety who stepped in has the right to terminate on the same basis that the contractor would have had the right to terminate, or whether that right has been lost due to the contractor's failure to give notice. So that would be an example of why it's important for sureties to keep an eye on what's going on the projects. Question 7, what is the best approach to take to enter into a contract with a municipality whose contract is very thin, language-wise, where penalties are outlined in place? What language can we propose? The tender came out during the pandemic and was awarded. There's a very inconsistent application of what is essential. For example, a rural road that is still intact but needs gravel topping is not healthcare, or possibly not. That sounds like a very specific question that I'm not going to be able to answer because I think the questioner has a very specific project in mind. But what I would say is that if you are about to enter into a contract with an owner, I think you should be sitting down with them to discuss how the parties are going to allocate the risks associated with the pandemic, and what will happen if the work becomes non-essential, and what will happen if the work is declared essential. And so that's a situation where the owner and the contractor are going to have to negotiate something, and so there's not really a one-size-fits-all approach to that, unfortunately. Last question. I think we've got 1 minute, so we'll see what we can do. Given that we're in the midst of the crisis, does one have to wait to submit a legal claim under force majeure or frustration? The answer would be just because we have a crisis doesn't mean you don't have notice requirements under your contract. So if your force majeure clause has been triggered, then you shouldn't wait. But if your force majeure clause has not been triggered yet, then you don't have the right to claim under it. So you can take steps to reduce the risk of waiting, such as by writing to the owner and asking them to waive delay under notice provisions, suggesting that the parties work out a specific COVID-19 related dispute resolution system, that sort of thing. But in general, I don't recommend waiting. Okay, I think that's all the time we have for today. Thanks very much for joining, everybody. I hope that was helpful. And if you have any questions or issues, please reach out to me or James.
Thank you, Krista and James, for your very valuable insight. The questions still keep coming, but in the respect of everyone's time, unfortunately, we have to stop the webinar right now. Thank you once again to both of you and to BLG for presenting this webinar today. Our 5th webinar on the series will be next Thursday, April 23rd, 2 p.m. Eastern Daylight Time, on construction worksite protocols for health and safety. Hope you can join us, and we will send the recording of this webinar to everybody who joined us today. Thank you, everybody, and enjoy a wonderful week and a weekend. Thank you.